Hi, my name is Todd Dupler. I'm the Chief Advocacy and Public Policy Officer for the Recording Academy. One of the most important missions of the Recording Academy is to advocate for music and for the people who make it. One part of that work is to educate and inform you about the issues that are facing music creators. So today I'm excited to present to you two conversations that I hope will equip you with information that you need to know. First, we're going to talk about the HITS Act, a really important piece of legislation that the Academy has been working on for 5 years that was signed into law just this summer. We're going to talk about how you can use it to impact your life as a music creator. And next, we're going to talk about international travel, a timely conversation about what international artists need to know before they attempt to travel to the United States. I hope you find these conversations meaningful, and I thank you for joining us. Hi, everyone. My name is Todd Dupler. I'm the Chief Advocacy and Public Policy Officer for the Recording Academy, and I'm excited to be here to talk with you about the HITS Act, the Help Independent Tracks Succeed Act. It's a tax bill, but don't let that scare you. This is something that is meant to help independent artists and creators and give them a real tangible benefit. So to help me talk about it, I'm thrilled with my two guests. First, I want to introduce Michelle Butler, who's the Managing Tax Director at PS Business Management.
Thank you. I'm very happy to be here.
And I'm especially privileged to be here with two-time Grammy winner, Nicole Zaritis. Nicole does a little bit of everything. You are a performer, you're a songwriter, you're a musician, you're a band leader and arranger, and you are also an independent creator.
So great to be here, Todd. Thank you for everything you've done for the music community.
Well, thank you very much. But as I like to tell our membership, the HITS Act is actually something that has happened because of our members like you. This is a legislative proposal that we have been working on at the Academy for going on 5 years now. And it's been years of advocacy effort from members like you that helped get this signed into law. So this year you were with us in Washington, D.C. You came to Grammys on the Hill and went to Capitol Hill to talk to lawmakers. And you've also been involved in our Music Advocacy Day through the years, where you're meeting with lawmakers locally here at home. So talk a little bit of just what that experience is like to go into a room and advocate on behalf of your community, and then see it come to fruition.
Sure. I mean, it's been an incredible thing to go and advocate for creator rights with fellow Recording Academy members to preserve and protect all of the things that we do and the music that we make. And you can do it on different levels. For me, it started by just going to District Advocacy Day, um, advocating with the congressional leaders right where I lived. When I lived in New York, I did it in New York. When I lived in Connecticut, I did it in Connecticut. And then we went to Grammys on the Hill, and that was an unbelievable experience. And my big takeaway was that the leadership in Congress and the representatives, they really wanted to hear from the artists themselves, and they listened, and they want to spark change for us. And it begins there, and we have the power to make it happen.
Amazing. Well, I love that story, and I love that the HITS Act is a really tangible example
Mm.
that the work that we do matters and that it can produce real results. And so thank you for being a part of that in the last few years.
It's really a pleasure.
So let's talk a little bit about what the HITS Act is. It was signed into law in July of this year.
Mhm.
And when does it take effect? When does it start?
So the HITS Act takes effect for any productions that are happening that start before the end of this tax year. So basically anything from July 4th through the end of the year would be eligible for the HITS Act benefits.
So it's something people can start using right away.
Yes, right away.
Great.
Mm-hmm.
So as we approach the end of this year, people are going to start thinking about their taxes. Maybe
Mhm.
some people won't think about it till a little closer to April.
Mhm.
But let's kind of unpack how this helps people.
Mhm.
The idea behind the law was for us to help independent artists and songwriters like Nicole, who often have to finance their own recordings. And so we added this to a section of the tax law called Section 181. And 181 already existed, but it was only for film and television production
Correct. And theater as well.
and theater.
Mhm.
So talk a little bit about why that section of the law is there and what it was originally intended to do.
Yep. So before 181, productions needed, and production companies and artists, they needed to amortize or depreciate all of the costs that were incurred with these productions over their, what we call, like, their useful life.
I'll pause you real quickly.
Yes.
Just break down what to amortize or depreciate means.
Yes. So that means if you paid a certain amount of money for something, you had to divide the cost of that over X amount of years. So different assets have different useful lives. But what we see is, a production company, they're incurring that cash up front, right? So they are spending that money today. But the way the code was written is that they're not getting the benefit of that deduction today. They were getting it over, 5 to 7 to 10 years instead.
So that was already in place for film and
Mhm.
television.
Correct.
That and live theater. Those work on a much different scale than music production.
Right, exactly. So, and that's why the HITS Act is so beneficial to our artists, is because we're talking about bigger companies that have more cash available to them. So for, a smaller artist to incur these expenses up front but not be able to take those deductions up front can really, be cumbersome to them, and can kind of have a lot more limitations on creating their music, which is what we want them to be able to do as freely as possible.
So rather than have to wait, this in theory allows them to take the benefit immediately.
Exactly.
Um, so we added sound recordings. I think that's the first thing, is to talk about what a sound recording is. And that's something where we basically just cross-referenced our existing copyright law to define a sound recording. So it's basically any sound that's fixed,
Correct.
whether it's music, but it could also be more than simply music.
Yeah, so any sound recording, the IRS basically defines it as any sound recording that's not connected to a TV, film, or other type of production.
So there's two different benefits in the HITS Act. One is to add sound recordings to Section 181 for expensing, but then it cross-references what you've referenced, bonus depreciation. Um, they sound kind of the same, but
Yes, yeah, so that's what can be confusing for people. So bonus depreciation and Section 181 are both different types of things where we're trying to get a benefit of an expense up front, right? But what bonus depreciation is different from the HITS Act is that there is no limitation. So the HITS Act has a limitation of up to $150,000 for sound recording production expenses. Bonus depreciation does not have that limitation, as well as bonus depreciation under the One Big Beautiful Bill Act was now made permanent into law. So the bonus depreciation was actually set to go away, but under the new bill, they created it again and made it permanent.
So there's no cap.
There's no cap, exactly.
So under the HITS Act, then we've added sound recordings to Section 181, but we've also cross-referenced it into the provisions around bonus depreciation. So you kind of have options.
You have the option, right? So if you are, for whatever reason, capped, and again, 181 is capped at $150,000. If you incurred more than that, you have the capability of using bonus depreciation. So again, now you're getting more of a benefit in the same current tax year.
So I want to bring it back to you, Nicole. We talked a little bit earlier before we sat down that you're independent. You've financed all of your own music through the years, but you've done things with your taxes to try to claim some benefits, to try to deduct some of your costs through the years, right? And so I think kind of curious to bring this together of what's different about what we did with the HITS Act versus maybe some of the things that Nicole and other artists have already done to try to ease the burden of their taxes with some of their music.
Right. Yeah. So what we see a lot is, a lot of artists receive advances up front where they're having to pick up that income, as soon as they receive that money. And then the way the code was written is they were supposed to, again, depreciate or amortize these production costs over X amount of years. And what that kind of unfortunately was doing is it's causing a little bit of a timing difference where artists are having to pay taxes on money that, they just received this money. They're not ready to put a production together, put an album together, and they're having to pay that tax up front, right? So what the HITS Act is doing is basically allowing artists to kind of marry the two things where they've picked up an advance, they're picking up the income, but now they're eligible to take those expenses as well. And we did have some artists that, may have not realized of what they were allowed to do or not allowed to do and picking up expenses maybe where they should have been depreciating or amortizing. And I think what the HITS Act does is give a lot of clarity in a IRC code that's very gray and it's not easy to read. And, a lot of artists are doing this on their own or don't have, an accountant or a business manager or someone that's kind of helping them and guiding them. But this provided a lot of clarity, which I think is great.
So now we know there's a specific place in the tax code that says music sound recordings are ineligible.
Or eligible, correct. Yeah.
So let's talk about some of those expenses. When you go to make a record, like what are some of the expenses that you would normally incur?
Well, it can go from a couple of different scopes. You can go all the way from a single all the way to a studio record. And I've ran the gamut with all of those. And so the first thing, you have to have the musicians. And so either they're session musicians or they're members of your band, or perhaps it's just you and you want to pay yourself in a perfect world. Then of course there's the studio costs, the studio rental, the engineer cost. Then we have the mixing, the mastering, we have editing, overdubs. If you want to do a string section, a horn section, the list goes on. And of course, if I'm producing an album, you're not going to go hungry. So catering is huge. On those long days in the studio, those are the top ones. It doesn't matter if you're doing a single or a full studio record. There's a lot of costs up front before you even get the sound recording. And the HITS Act is great for just leveling the playing field to get rid of the gray area.
Right.
So talk about, there's a lot of different costs packed into that. We had labor costs and bringing in other musicians and artists to perform with you. There's kind of the hard cost of renting that physical space of the studio. You have the personnel in the studio that are producing and mixing and engineering the music. Does that all count?
Yeah, so those are all considered production costs. And those would all be eligible to take and get expensed. Yeah, that would be good.
Okay, but the really important question, what about the catering?
So the catering is considered as long as it's part of the production. That is eligible. Yeah.
And so for you, what kind of difference does that make as you think about your career, as you think about the music you're going to be making in the future?
Well, it's nice to know now. I keep mentioning the gray area. Before, it always just felt like I'm writing these things off, but is it allowed? Is it a just necessary expense? Is this a Schedule C? Is this a blank? So this clears that anxiety. And then when you are able to reduce your income, that clears more income for you to make more art. And as independent artists, the return of investment, the ROI on our albums, it's tricky. Not everyone has success in actually ever receiving. So the loss is already there, and to know that we at least have a potential tax benefit is really important for us to continue to create.
That's exactly what we hoped for when we first thought of this idea, was how can we help artists like you have the freedom to just think about creating and not have to think about the financial burden quite so much. Quite so much. Maybe we can't completely solve it, but we can make it better.
Right.
So let's talk a little bit about timing, because you mentioned earlier that bonus depreciation, because of this bill, is now permanent. But what about the Section 181 part
So
of this act?
181 is set to expire at the end of this year. So while under the One Big Beautiful Bill Act, they extended this to sound recordings, which is great. They didn't, in fact, extend it past its original sunset date, which is December 31st of this year. So there are people out there like Todd that is working really hard to get this extended, which would, I think that's seeing the benefit and allowing artists to actually reap the benefit of this is the importance will be to extend it past its current sunset date.
So you're right. That is something we're working really hard on in Washington, with a broad array of stakeholders. We worked especially closely with A2IM to get the IDS Act passed into law. We're working with other music stakeholders like the RIAA, but also our friends in the motion picture industry who also want to see this extended. But I think it's interesting, especially in this provision, we've seen this expire and be extended. It's kind of part of the life cycle of how 181 works.
Yeah, exactly. It is common for things to sunset and get renewed. This is why we see this every few years in Congress. These are the things that are set to expire. What is Congress going to do about it? And then the people that are involved to try to push, and get things extended. So, yeah, I wouldn't fret so much about it. It is pretty common, and it is also extremely common for things to go down to the very wire.
Yes, we're very used to that.
Yeah.
So another difference between these two provisions is that Section 181 applies to the year that costs were incurred, and bonus depreciation applies to when the product was placed into service. Could you talk a little bit about the difference of what those two things mean, and then especially in the context of a sound recording of music?
Yeah. So bonus depreciation, the definition of being placed in service is you may have purchased something or a piece of equipment for sound recording, right? But if it is not actually ready for use for whatever reason, if it's something that needs to be put together or it's something that you don't have in your possession yet, so you can't actually use it. Um, the difference here is like your purchase date versus your actual like readily available for use date. And that's what the placed in service is. And for Section 181, the difference there is whenever you're incurring the costs is when that's eligible to be part of the production costs, to be part of the election.
I'm curious for you, when you make a new record, how often is there a delay between when you produce the record, record it, versus when you choose to release it? What does that time horizon look like, and what goes into that kind of decision making?
That's a great question. I mean, How Love Begins, I began recording that in December 2021, and I didn't release it until July 2023. The time period varies for every artist, independent or label, and it all depends on when is the best time for the artist to release it. So it sounds like this could also benefit us.
Yes. So ideally, especially if we get 181 extended, artists would have options of
Yeah.
when to exercise which provision.
Exactly. So it's always best to look at your total tax situation for the year, right? And why all these decisions aren't really made until you're filing the tax return is because you're looking to see, well, should we do 181 for this piece? Is there a separate project that you're starting that maybe we use bonus depreciation for that piece of it? And we're always looking to maximize those deductions as much as possible.
And so is it possible to use both? You both
It is possible to use both. You just can't use them on the same pieces of equipment, the same expenses, right? So if you are finishing an album in February, that could be part of your 181 election expenses that you're using. And then you're starting something later in the year that maybe then we use bonus depreciation to be able to take the deduction on that.
Look at that. The more you know.
There is a lot in the tax code, and that's the thing. It's not always out there, and artists are, again, you're supposed to be making music. You're not supposed to be worried about what your taxes look like at the end of the year. So it's helpful to have things like this where we're putting the information out there for people to use it and just kind of, you know, have it in the back of their mind to remember a little bit, and then we can come back and talk about it in April.
We're a musician household. Like my husband is also a full-time musician, drummer, composer, and then there's me. So it's good to know about both sides of this act.
So, what would be some examples of things that aren't eligible expenses that maybe an artist might assume they could use or might want to try to
Mhm.
apply, but doesn't fall in the scope of this?
Right. So, for example, marketing and advertising costs. So they don't fall under production costs for Section 181 or the HITS Act, but they are still necessary and ordinary expenses that you can use and you can take as an expense for the year. So it is still a tax deduction. It's just making sure that you're putting things in the right places on your tax return, as you referenced earlier.
That's interesting. I actually have a question. Um, a lot of time the artists will record themselves, video, not necessarily for marketing, but maybe as part of the release plan. Would the video count the videographer fee under the HITS Act? Would
Yeah,
it be
so
a different expense?
that's the thing. I think if you're saying that, yes, this is being used for the recording, right, and it's not really being used for marketing, that's something that we can discuss. Maybe then that is a production cost versus, um, it's always, and what I try to do is ask a lot of questions to really understand because, um, again, I'm looking at numbers from a bank statement or other, and I want to know really what's the real story here. Because a lot of the times talking to the artists is what then we're like, oh, well, then this should go here instead of here. And this would be a better benefit to them. And there is no audit risk in doing this. So it's really important to kind of know the whole story.
So, a question for you, because you were also a songwriter, do you sometimes make demo recordings of songs that aren't, it's not the final track, but you're creating the demo recording to kind of try out ideas and see what something sounds like?
I'm really glad you brought this up because I was thinking about this. Yeah, oftentimes, especially for songwriters, you make demos. We have to either pay the session musician or we have to pay an engineer, and then we have the demo themselves that aren't going to be released.
Right.
So how does this fit for us?
So, I think that's an excellent question. And it was certainly our intention when we created the legislation that we recognize that there are songwriters who also pay out of pocket to make a demo recording, but they're not the artist.
Mhm.
So, how could a songwriter in that situation
Mhm.
take advantage of this?
So that's important to know, to note is artists who are creating these demo recordings, they are still eligible to take these expenses, right? I think it's the IRS again, there's a lot of gray, right? They define just a sound recording as any sound recording that's not tied to a TV or a film or a theater production. There's no specifics in the code as the way it's currently written to kind of define them as separate pieces of sound. So yeah, you can definitely take those.
That's great. Okay, so let's move into kind of the practicality. Let's say in your instance, you're thinking ahead of tax season. What what does an artist need to know? What are the things they need to be collecting,
Mhm.
keeping track of? I guess what is already as an independent artist, what is your own system for that? Do you think about keeping track of expenses of paperwork and kind of what's been your default setting for that?
Oh, absolutely. Especially as a two musician household, most of what comes into our business account goes out. And that's just the nature of the beast. And so we try to have one credit card for business that's attached to our business account so that every time there's a expense, it goes straight from our business account to that credit card. So it's easy to find at the end of the year. We will have independent contractors invoice us for work for hire that we pay them, and then any other tax deductions we have spreadsheets from previous years that I always reference. And luckily, once you do a good job once, you you will probably have repetitive, not numbers, but repetitive deductions in the future. So that's helped. It's still intimidating, especially for indies, but it's possible. I'm sure Michelle has some great ideas.
So how's she doing?
Yes, no, I mean, so that's great. No, that's what's really important is, and especially for young artists, is getting them off on the right foot, right? So starting out knowing exactly how to set up your business or how to set up your everyday so that it's easy for you, but also gives us the most information, right? So that was a great idea, like having one credit card attached to your business account so that every time you're doing something, you're using that credit card. While it's not, it's not a bad thing or it's not, it doesn't make an expense ineligible if you put it on your personal credit card, because we have people that do that all the time and accidentally grab the wrong thing but what it does is for audits, for example, it makes everything clean and organized. And that's the biggest in all my years working with auditors is the more organized you are and the more organized you give them the information, the smoother the whole process goes, right? What they look for is something like that. If you made a big purchase on your personal, debit card, credit card, and then you're trying to say it's a business expense, right? And everything else is on your on a business card, then they're like, well, why did you use your personal for that? Right? Maybe you're trying to sneak something in that shouldn't be an eligible deduction. So it's just smoother to have everything. You're able to use your bank statements, of course, credit card statements. A lot of auditors, what they'll do is that'll be their starting point. And then if there are bigger transactions, they'll kind of cherry pick them and say, well, hey, I need the invoice for this to kind of prove, they want to see the vendor, they want to see the date, the amounts, kind of a description of whatever that cost was.
Any other best practices or tips that you would advise people to make sure you're thinking about this?
I think having a great accountant is a good
Accountant?
yeah, I think having a good accountant, but I think, you know, keeping yourself organized and having the right people around you is really important to, make sure you're getting all your deductions, you're doing everything definitely by the book, right? We don't want the IRS to come knocking. But yeah, that's
And would you say that independent artists or any artist should start an S corp versus an LLC? Should they remain their own personal? Would that be between them and the accountants? I know that we went back and forth whether S corp or LLC.
Mhm.
But does it matter with the HITS Act?
So the HIT Act doesn't come into play with whether you should be an LLC or an S corp. I think that is very just dependent on every person's situation is a little bit different.
Right.
Having an LLC is great for your liability purposes. You want to, and a lot of people, they don't want their name out there. They don't want their social security number on all the documents. So having an LLC is great just for that privacy piece of it, that you can have an EIN and it's not your personal information out there all the time. Um, but yeah, an S corp is another, it's something that we look at for artists as they start to become, they start to make more money. Then we say, well, let's look at the benefits of now electing S corp status versus staying in LLC. And there's other parts of the tax code, which would probably be a whole separate chat here. That yeah, it would be beneficial.
And I guess technically under the law, though, even if you file as an individual, you can
Mhm.
still take advantage of these provisions.
Yeah, no, and as Nicole mentioned before, something is called a Schedule C, where you are self-employed and you are picking up all those expenses. So you don't need an LLC or an entity to do this, but it is, again, that's more for legal liability and privacy purposes that people do that.
Right. Any other questions that you know? Bowie?
I think this was super, super helpful. And I really hope that people take advantage of this.
Absolutely. Well, I really appreciate both of you for sharing your time and your experience. And I really expect and hope that the HITS Act will be really beneficial to a lot of people.
Yeah.
Thank you.
Thanks for having us.
Hello, everyone. We are here today to talk about international travel for artists abroad. I know many of us have seen in the news different stories about artists that are making the choice to cancel their shows, not go on tour because They just don't know what to expect or what's going to happen to them if they try to come to the United States. So many of our members are either international artists themselves or work with international artists. And so we want to spend a few minutes today talking about what's really happening in the travel space and what artists need to know to be prepared and equipped to make good decisions. So I'm really pleased to be joined today by Will Spitz. Will is a partner at the Covey Law Firm and also does work with the nonprofit Thomas Dot. Tell us a little bit about the work that you do and also tell us about Thomas Dot.
Sure, yeah. Well, first of all, thanks for having me, Todd, in this beautiful building here. So, as you said, I'm a partner at a firm called Covey Law in Brooklyn, where I lead our performing artist visas team, which focuses on helping artists secure O and P visas to tour in the U.S. And then I also do some work with our affiliated nonprofit organization, which is called Thomas Dot, which does a variety of different things related to international cultural mobility and international cultural exchange. Thomas Dot does advocacy work in that realm, trying to advocate to make what can be a very difficult and onerous and expensive process to try to advocate for common sense changes to make that process a bit easier. It's an uphill battle, but we're working on it. And education work. We go to conferences and festivals throughout the world and talk about U.S. visas and the artist visa process.
Well, thank you for being with us. I know the Academy and Thomas Dodd have worked together along with other like-minded organizations on visa reform, and really appreciate you taking the time to help us out today. Why don't we start with just kind of some level setting, because I think a lot of people don't understand what it takes to come to the United States and when you need a visa, when you don't, what the different purposes are. So can you kind of help us just understand the starting point?
Sure, yeah. So if you're a performer, the place to start is if you are coming to the US to perform, you probably need a work visa. And when I say work visa, there are two categories, O visas and P visas. Those are the two main categories available to artists. There are several narrow exceptions to that general rule, but they're very narrow and they don't necessarily depend on whether or not the artist is being paid. A couple of the most important exceptions probably for your members, the showcase exception. So that applies in certain industry showcase contexts. If the audience that is there to watching the artist play is there not necessarily to be entertained, but to consider some sort of business engagement with the artist. So South by Southwest is an example. There's one for certain academic performances. There's an exception for cultural programs that are sponsored by the artist's home country. Again, they're very narrow, they're very nuanced, and the place to start is to assume that you need a work visa. The question that we always get is, well, how, let's say you've got an artist who has a record coming out and they're doing a promo show in New York, they're doing a promo show in LA, they're not getting paid. In fact, they're losing a tremendous amount of money. And the question becomes, well, how could this be considered employment, requiring an employment visa if I'm not being paid and in fact I'm losing all this money? I think the way to think about it is sort of from the perspective of U.S. immigration policy, which is designed to protect U.S. workers. So, if you think about it from that perspective, an artist who's coming and playing a show, entertaining a room full of people, doing it for free is almost even worse than getting paid and not having a visa, because you're taking a job from a U.S. worker. That's the thinking behind it, and even depressing the value of U.S. labor. It doesn't really make sense in this context most of the time, but that's sort of the thinking behind the rules.
Let's say you're not the performing artist, but maybe you're the artist's manager, or you're a musician that tours with the artist, or some of the other staff that accompanies an artist when they're going on tour. How do these rules apply to that?
Yeah, so if you are working directly on an artist show, for example, you're the tour manager or you're the front of house engineer, or anything that is an activity that's directly related or working directly on on shows on a tour, then you need a work visa. There are certain support visa classifications that are available to the support staff of touring artists. If you are just the artist manager and you are there to be at the shows and big markets, to have meetings with the label and the agency, schmoozing at the shows, that sort of thing, you probably don't need a work visa. Artist managers generally are okay to come either on an ESTA, which is the visa waiver documentation, if you're from a visa waiver country and you're eligible for a visa waiver, or on a B1 visitor visa, that's a business visitor visa. ESTA and B1 visas allow the same activities, so they're very similar. The purposes are the same. It's just whether or not you are eligible to travel under the visa waiver program determines whether or not you need a B1 visa. But the B1 visa, even if you do need a B1 visa, that process is much easier, more straightforward, significantly less expensive than getting an O or a P work visa.
So let's say you're an artist, you decided you do need an O or a P visa. What is the difference between the O and the P visa?
There's the main category of O visa is called O1, and it's for individual artists of extraordinary ability. Extraordinary ability is the terminology that the government uses. It basically means an individual artist who's renowned in their field. You don't need to be a household name, but you need to have some sort of, career achievements, press, impressive shows, that sort of thing. And then the support classification, the corresponding support classification for an O1 visa is called O2, and that's available to backing performers, so like backing band of a solo artist, or dancers, or the tour manager, the sound engineers, the guitar tech. They can all get O2 visas. P visas, the main category that's relevant for Recording Academy members is P1, which is for internationally recognized entertainment groups, so basically bands. And then the corresponding support classification is P1S. There's also P2, which essentially for musicians is only available to Canadian musicians. And then there's P3, which is for culturally unique artists. The idea with the P3 is not necessarily like unique, one of a kind, no one else does this sort of performance. It means unique to a certain country, certain nationality, certain group of people. So traditional Irish folk music, for example, or something that's unique to a certain group of people. But the main ones, I think, for our purposes are the O1 and the P1, and it's usually the O1 is for solo artists. Usually groups get a P1. Sometimes you can explore, you can get an O1 for the front person of a band and O2s for everybody else. But I think that general distinction is most important, yeah.
So I think certainly we've seen that changing landscape this year, but even prior to this year, there have been a lot of challenges with the visa system, especially for artists coming in on the O and the P visa. Let's talk a little bit about the story so far before we got to the new administration, of just what some of those challenges have been.
Well, first of all, to take a big step back, this process has always been difficult, or it's been difficult for, I don't know, at least 2 decades. And it's forever getting a little bit more difficult, a little more expensive, a little more unpredictable and complex. The two sort of big changes that happened last spring were there was a fee increase. The government filing fee increased in, I think, April of 2024, which was significant, but not as significant as the second change we saw, which is a little bit more complex. I'll try to summarize it quickly. Essentially, in the spring of last year, in spring of 2024, they changed the filing location. So there used to be, try to make a long story short, there used to be 2 offices where you filed O and P visa petitions, an office in Vermont, an office in California. Vermont historically was pretty fast, pretty predictable. California was generally pretty slow and somewhat unpredictable. They centralized all the filings in spring of last year, so that now everything gets sent to one address, and then they were sort of randomly distributing the cases between Vermont and California. The overall effect is that processing times in general just slowed way down. Now the waiting times on these cases are more like 6, 7, 8 months. Some longer. We have cases that have been pending for over a year, which is insane when you consider the fact that you can't file more than a year in advance. So the upshot of that has been that almost everyone now is having to pay the fairly significant expediting fee to the government.
Those fee increases and the need to do the premium processing, especially hit hard the nonprofit sector. Kind of talk a little bit about the impact that they've seen and why they're maybe less equipped or less able to make that response the way other artists or sponsors might be able to.
Well, it's interesting because there was when they did the fee increase, there's a carve out for nonprofits, and the increase for nonprofit petitioners is significantly lower than for big for-profit employers, which is nice, but the impact of the premium processing fee, I mean, this is already a really expensive process, and margins are already really tight for independent artists, for the nonprofit presenters of the world. And so adding $2,800 or $5,600 if you've got support personnel, because then it's 2 petitions, the impact of that is significant. It can be the difference between breaking even on a tour and losing several $1,000s, which, again, because this process is already expensive and because everything's getting more expensive, renting gear is more expensive. Unfortunately, there are some artists on the, less commercial end of the spectrum that are making the decision to skip the US now until the situation improves, which is really disappointing as an American music fan.
So we already had this challenging landscape with processing times that are unpredictable, stretching longer. We had this fee increase go in place. As you mentioned, we mitigated it a little bit in some circumstances, but it was still a big increase. Now we have a changeover, a new administration comes in, which has taken a very aggressive stance on immigration policy pretty much across the board. So we've seen a few different changes go in place that have shifted the landscape further. So let's start first, again, with costs and fees. What has this administration done on top of what was already done last year?
Yeah, well, so nothing yet. They've in the Trump's big beautiful bill, there is a provision that allows them to charge a visa integrity fee, is what they're calling it, which is basically supposed to be, I guess, like a bond, I guess. The idea is like if you're a visitor to the U.S., you pay some fee. They haven't determined what that will be or how it will be charged or when. You pay a fee and then you get it back when you leave the U.S., provided you can demonstrate that you didn't violate the terms of your visa. Now, it's totally unclear how that will be. The mechanics of that are sort of mind-boggling. I can't imagine how they would implement that, and they haven't yet. So that's something that's sort of floating out there on the horizon, but it hasn't happened yet. So I don't think at this point there's any reason to worry too much about that.
Fee increases, I suppose, in other visa categories.
Yeah.
But not in these Owen.
Yeah, I mean, there's an enormous, big news recently, this enormous additional fee added to H-1B visas, $100,000 fee, which is unpayable by most H-1B sponsors. But that has not affected O&P visas. It hasn't affected musicians. I've been getting questions from clients like, is it possible they're going to do the same thing with O visas? And, I don't think that's likely. I don't think artist visas are in the administration's sights the way that H-1B visas were. But, it's a pretty unpredictable situation, and anything could happen. But as of now, the fees are the same as they were.
Another issue, this administration has talked about travel bans. They did this in the first Trump administration. They talked about it again this time around of banning travel from certain countries. What's the status of that, and how does that potentially impact artists?
Yeah, there are travel bans in place right now on individuals coming from certain countries, Iran, Haiti. There's a list. It's not a huge list, but there is a provision in the order, the travel ban, that says if you can show that the individual's travel is in the national interest, then you can get an exception to the travel ban. We are currently working on a test case. We haven't filed it yet. It remains to be seen. I mean, the people that I've talked to in the immigration law community have been very pessimistic about how likely, the chances of getting one of those waivers. We did have some success in the first Trump administration getting national interest waivers for artists, but that remains to be seen. But yeah, that's an unfortunate, a discrete situation, but it is a problem.
All right, so let's talk about scrutiny, about what they're doing to make these determinations, what things are coming into consideration, how are they deciding who to give visas to, what's the shift or the change there?
Yeah, so people are concerned. There's a lot of anxiety about traveling to the U.S. right now. There have been stories about people's phones getting searched, people getting detained and, put in secondary inspection for a day and then sent home. There's been people having visas revoked. There's a lot of these stories in the news. And so I understand the concern. I think the good news for artists is that there hasn't been a significant pattern of heightened scrutiny on artists, especially artists who are coming with the right visa. We haven't had any, knock on wood, we haven't had any clients have any significant problems. If they're qualified for the visa, they're getting the visa. If they have the visa, they're generally getting into the country fine. I think the area where I would be concerned, and what I've been telling people, is if you are coming pursuant to one of the exceptions that we talked about earlier, or if you're coming without a work visa and you're doing something work related and it's a gray area about whether you need a visa, those are the types of situations that I'm cautioning people about, because while again there's no large pattern of artists facing higher scrutiny, there are individual officers. There's a climate of heightened scrutiny, and there's individual immigration officers who feel emboldened to to subject people to higher scrutiny than they would have a year ago. In addition to the travel ban that we just talked about, the travel bans, there's a sort of major caveat to that, and that is for trans people, gender nonconforming people, intersex people. The administration's policy regarding gender is impacting those communities. Basically, the quick backstory is that early in the administration, Trump signed an executive order basically decreeing that there are only two sexes. Gender is not a thing. There are two sexes, and they can't be changed. So whatever your sex is at birth is what needs to go on your visa application, basically. And so we've had a bunch of trans clients who are put in an uncomfortable situation where they either have to out themselves as trans and they've got a female passport, but they were assigned male at birth. They either have to say that they're male on their visa application, and then their visa says male even though their passport says female, or indicate their true gender and then have to deal with the scrutiny that comes from that. Fortunately, we've had clients do both. And fortunately, I think all of our trans clients who have applied for visas and have been able to get visas and enter the US. We've had trans clients be asked for their birth certificate, and then so just to give a quick example, a female client whose gender identity is female, they are female. They were assigned male at birth. Their birth certificate says male, but they put female on their application, or she put female on her application, and at her visa interview at the U.S. Embassy, was asked for a copy of her birth certificate, and then it delayed the process. I think it was like a month or a month and a half went by, and finally they approved her application, but her visa says male on it, which is upsetting. But ultimately she was able to come and tour and had a successful tour, and so I don't know, but that is something to be aware of.
That really leads to kind of the last bucket I wanted to talk about, which is kind of documentation, right? How do you prepare yourself? Because it sounds like despite the anxiety, and we've seen some specific cases where artists have had terrible experiences, it sounds like if your documentation is in order, if you follow the process, for the most part, there haven't been systemic problems for artists traveling. So how do we prepare artists to be ready to do that so that they can navigate it safely and carefully? What would you say? How do you start getting things in order?
Yeah, well, first of all, I think the first question is always, do I need a work visa? And so start there. And if you do, start as far in advance as you can, because there's very often unforeseen delays. And as we talked about, the processing times are very long. And then if you get a work visa and you're coming to tour, make sure you know your itinerary, you know what you're coming to do, you know that your activities are, okay under the visa that you have. If you're coming without a work visa, if you're doing something that's the business manager example, make sure that you are prepared to articulate what you do, why it's okay without a visa, and having your itinerary. And it can help to show, like, well, I'm going to New York for the first show of the tour, and I'm staying in New York while the artist goes on to Philly and DC and does the rest of their tour, because I'm going to be meeting with the record label and the booking agency, and then I'm going to meet them in LA for the LA show, and sort of to be ready to articulate what you are doing and why. A question that we're getting a lot is, well, I've heard all these stories about people's phones being searched. They're using AI to go through social media. Should I be worried about, the pro-Palestinian Facebook post that I posted a month ago? Or, I've been vocally, anti-Trump on stage and in my socials. I think, and so the question that we're getting a lot is, do I have to scrub my social media? Do I have to be careful about what I say? And that's a really difficult question to answer. I think basically we're not seeing a pattern of artists being carefully scrutinized for their speech. There are high profile exceptions, the Kneecaps and Bob Villans of the world. But those are pretty particular situations, and the vast majority, we have plenty of clients who have been outspoken critics of the administration, who have been vocal in their support of Palestine, who have had no problems. But I say that with the big caveat being, this could change tomorrow. The administration could expand its scope of focus from, the academics and student protesters that they've sort of focused a lot of their attention on. They could expand that to look at artists and scrutinize artists' past statements. It's not happening yet in any sort of meaningful, significant way, but it could. And I think it's important that your members are aware of, where we're at with that, and keep your eye on, the news and resources. Thomas Dot, for example, has we keep, and the firm Covey Law, we have FAQs on our website that we're updating regularly. We send out email blasts. People can sign up for our email list. If there are changes that affect the artist community, we're putting them out there and letting people know.
What would you say is the most common mistake that you see artists make in putting together a visa application?
Well, I think the most common mistake is performing in the US without a visa and doing, flying under the radar, and then often getting away with it, but that it can come back to bite you later when your fan base has, grown and you're playing bigger venues and it's time to get serious and get a visa. They can go back and look and see that you, when I say they, I mean US immigration, can see that you've played. They can go on your social media. They can look at your, bands in town page and see past shows. And so even if you got away with it at the time, it can come back to bite you later. They could deny a future visa application because you performed in the US. So I think the most important thing first is just knowing if you need a visa and getting the proper visa if you need one, and starting that process as far in advance as you can.
All right. Well, this has been a lot of really useful, good information. I know anxiety is running very high. I think hopefully this has been somewhat reassuring, I think, for a lot of our members to know that despite the climate and the atmosphere, and despite the costs and that are involved, that the process is working for artists that follow the steps, get the right visa, have the right documentation in place. Thank you for taking time to talk through this with us. Again, I encourage everybody to look at the Thomas Dot website, because there are great resources there. I've referenced it as well. But I just want to thank you again for taking time with us today.
Yeah, thanks, Todd. This was great. A lot of fun.